the argument on the motion to dismiss.
All right, I'll present the argument on the motion to dismiss them. As I stated at the outset, my name is Mike McElroy. I represent the town of Burrillville. Invenergy is proposing a natural gas and oil-fired plant in Burrillville of up to 1,000 megawatts. If approved, this plant would be, as I've said in the past, a polluting monster. Why have I said that? Over 50 known pollutants would be spewed from its 200-foot tall stacks. These include hundreds of thousands of pounds of poisonous nitrogen oxides per year, hundreds of thousands of pounds of toxic carbon monoxide per year, and billions, with a B, of pounds of carbon dioxide per year. In fact, this would represent a 38% increase in the current energy-related Rhode Island carbon dioxide emissions. These carbon dioxide emissions are the equivalent of adding almost 750,000 cars in Rhode Island. That is nearly twice the number of cars that already exist in Rhode Island. These huge carbon dioxide emissions would make it nearly impossible for Rhode Island to meet the carbon emission goals of the Resilient Rhode Island Act. If approved, this plant would force another power plant on Burrillville, which is already burdened with the Ocean State Power Plant gas plant that was forced on the town by the state, and the Spectra gas compressor station that was forced on the town by the federal government. Burrillville has sacrificed enough. The proposed plant should not be sited in Burrillville. EFSB Rule 1.6b11 requires an application to specify all required support facilities, specifically including water, and, quote, an analysis of the availability of the facilities and or resources of the project, quote, must be done. In this case, Invenergy originally proposed that, as is usual with power plants, water for the facility would be transmitted from a water supplier by water pipes, and that wastewater associated with the plant would leave by sewer pipes. As late as its December 12th filing with this board, Invenergy said that water would be obtained by, quote, a new dedicated water pipeline, quote, from Woonsocket. The line would be 14 miles long and there would be a new pumping station in Woonsocket. In its December filing, Invenergy said that wastewater would be discharged to the Burrillville sanitary sewer system, quote, by the use of a new forced main. We concede that one alternative briefly mentioned was the possibility of using a demineralized water treatment system that could make trucking of water feasible. But that was essentially an afterthought in the status report. At no time in the December status report was there ever mention of Johnston as a possible water source. Woonsocket then rejected Invenergy's water request, but that same evening, with only minimal notice, no public hearings, and no substantive discussions, the town of Johnston voted to supply water to Invenergy. That vote is now the subject of multiple legal challenges for alleged violations of the Open Meetings Act. If the Open Meetings Act was violated, that vote could be declared null and void. On January 11th, Invenergy eventually filed a revised water plan that drastically changes the way Invenergy proposes to operate this plant. Invenergy now claims that it can dramatically reduce water usage by engineering changes at the plant, that it will truck water in huge tanker trucks instead of building a water line, and that it will truck waste in these huge tanker trucks instead of building a sewer line. At this time, it is unclear how and to what extent the revised water plan and the altered operating conditions at the plant would affect the town. The town is ready to hire a power plant process engineer to study this water plan and to provide recommendations and analysis. In the meantime, the town has already sent over 50 data requests to Invenergy to start exploring the potential impacts of this water plan and the changes it proposes. I believe the single most important data request is number 48, which is attached to the filing that I made. It says, quote, what effect, if any, will the change in operating procedures as set forth in the water plan have on data previously provided in the application and data responses? Please explain. Other data requests deal with such matters as the effect of the recently revealed increase in the estimated cost of the project by $300 million from the original estimate of $700 million to the newest estimate of $1 billion. The increase in ammonia truck deliveries disclosed for the first time in the water plan. How many trucks will be traveling Burrillville's narrow roads and attempting to negotiate its very tight and dangerous intersections? Details of the proposed on-site wastewater treatment system. The operation of the proposed demineralization trailers. The additional emissions that would be emitted by the fleet of new tanker trucks that will be coming to the plant through Burrillville. In addition, we expect and urge that pursuant to EFSB Rule 1.9F, this board will want to ask the advisory agencies that were previously designated and who would be concerned about the water issue to study the water plan in detail and to render supplemental advisory opinions to this board. At a minimum, we believe that the agencies that should be asked for supplemental opinions are the town's planning board, the town's zoning board, the town's building inspector, the Department of Health, the Department of Environmental Management, the Department of Transportation, and statewide planning. Now, on September 13, 2016, the town filed a motion to dismiss Invenergy's application because its proposed water source in Pasco had been eliminated on August 19th when the Pasco Utility District terminated its non-binding letter of intent with Invenergy. A non-binding letter of intent was the way Invenergy chose to handle that matter. Invenergy also attempted to obtain water from Harrisville, but that failed. This left the application, as this board has conceded, incomplete, because a power plant cannot operate without water. On October 3rd, this board issued a show cause order, and on October 13th, after the show cause hearing, this board agreed that Invenergy's application was in fact incomplete due to the absence of a water supply plan, and therefore was not in compliance with this board's Rule 1.6b4. However, instead of dismissing the application as the town and CLF urged, this board suspended the application for 90 days, quote, to remedy the incomplete application, quote. On the last day of the suspension period, January 11th, Invenergy filed a water plan that, as I have pointed out, was significantly different from what was proposed in its initial application and what was proposed in the status report it had filed less than a month earlier. Instead of piping water in and piping discharge out, Invenergy is now proposing to truck water in and to truck discharge out. Invenergy also claims it can dramatically reduce water usage with this significant change in plant operations that needs to be explored in detail. The town submits that this water plan is simply not viable for a number of reasons. If the water plan is not viable, then the deficiency has not been cured. The first reason is that the plan itself, as I think the board acknowledges, raises many more questions than it answers. At a minimum, those questions must be explored by experts and the relevant advisory agencies. Second, the plan proposes to obtain water from the town of Johnston, which purchases wholesale water from Providence Water Supply Board. However, on Thursday, February 2nd, the Providence City Council passed 3 resolutions which said, among other things, the following. A. Providence unequivocally opposed the siting of the plant in Burrillville. B. Providence expressed serious concerns over the use of the water from Providence Water. C. Providence expressed its intention, quote, to prevent the use of Providence water at the CREC power plant, quote, and its intention to explore, quote, the legality of the resale and markup of Providence water, quote, by Johnston. D. Providence urged the, quote, General Assembly to enact legislation restricting the resale of excess publicly provided potable water by municipalities, quote. And E. Providence stated that, quote, the Providence City Council supports the introduction and passage of state legislation that requires municipal water suppliers that purchase water from Providence Water or other water utilities at wholesale rates to limit resale of that water to customers located within the municipality. Third, The two Johnston water documents that were submitted with the water plan are simply not binding legal contracts. They are illusory, is the legal term. They are therefore unenforceable, rendering the plan not viable legally. There are two documents that were attached. The first is from Ben Water. This one is simple. It is a mere letter of intent or an agreement to agree. It states in part, quote, "In the event due diligence is completed to CREC's sole satisfaction, the parties will negotiate in good faith and enter into a long-term water supply and/or transport agreement, omissions, governing said supply and/or transport, which shall include, at a minimum, the terms outlined herein." That's paragraph 5 of that document. This is simply not a binding legal contract that could support this water plan. It is a non-binding letter of intent. It is quite similar to the Pasco Utility District letter of intent that was not legally binding and allowed the Pasco Utility District to opt not to provide water to Invenergy at the last minute. The second document, the Johnston water document, it is similarly unenforceable for the same reason. It is an illusory promise. Putting aside the important issue of whether the Johnston Town Council vote will soon be declared null and void in violation of the Open Meetings Act for the use of a rolling quorum, the agreement is clearly illusory. In paragraph 14, little I, it states, quote, "Contingencies to agreement. This agreement is expressly subject to and conditioned upon the project securing final licensure from the Rhode Island Energy Facility Siting Board, with all applicable appeal periods having expired, said licensure remaining in full force and effect during the term hereof, and the project coming to a financial closure on project finance on terms deemed acceptable to CREC in CREC's sole discretion. If said contingencies are not satisfied, the obligations of CREC and/or CREC hereunder do not come into full force and effect." The Rhode Island Supreme Court, in the case of Vickers versus Vickers, 610 Atlantic 2nd 120, adopted the definition of what constitutes an illusory promise from the treatise Corbin on Contracts, and the Supreme Court stated as follows: "An illusory promise is one comprising words that form a promise that is conditional on some fact or event that is wholly under the promisor's control, and his bringing about is left wholly to his own will and discretion." End quote. Because Invenergy can back out of the Johnston deal if the terms for financing are deemed unacceptable by CREC in CREC's sole discretion, this arrangement is totally within CREC's control. Therefore, it is not an enforceable contract. Moreover, the document itself makes it clear in that same paragraph that until this board issues a final unappealable license and the financial closing occurs, quote, "the obligations of CREC do not come into full force and effect," end quote. Therefore, even if this promise was not illusory, which it is, then at this time, the water deal with Invenergy, by the clear terms of the Johnston document, are not yet in effect. The town of Burrillville therefore submits that the proposed water plan has not been demonstrated to be either practically or legally viable at this time. Under Rule 1.13c, it is Invenergy that has the burden of proof to put forth every aspect of its application. We submit it has not met that burden with this water plan, and the application therefore remains incomplete. The town and the other parties should not be subjected to endless expensive litigation over this polluting monster. After 15 months, we believe that the time has now come to close this docket and dismiss the application with full prejudice. And again, I've got to note my objection for the record that this is not only a strange, but I believe a procedure that violates the due process rights of the town of Burrillville, as well as every other party participating in this. The board has clearly already made up its mind. Can I be heard? The board has already made up its mind. Thank you, I'm sorry to interrupt.
Why is this motion not moot?
It's clearly not moot, it's pending, and the reason it's pending, and our argument, which I tried to make clear, is that if the water plan is not legally viable,
Isn't that something that's a matter to prove at the final hearings? When there'll be evidence and testimony on the issues regarding the water plan as well as all of the other matters that are in.
I don't think, Chairwoman, that it makes sense for the parties to re-engage in this application process and to spend the hundreds of thousands of dollars that it will take to move this process forward to final hearings when they have pending before you now an incomplete application with a water plan that is not legally viable. Let's deal with that issue first, because if that issue, if we are correct in our interpretation of that issue, then this docket needs to be closed. Now, would I object to a 45-day postponement?
Your motion was based on there being no water. The company has provided a revised water plan. There's ongoing discovery from the town of Burrillville as well as a number of other parties regarding additional details about the water plan. Why can't that discovery continue?
It certainly can, but the issue here is, let's assume, simply for the sake of argument, they had filed a water plan, and the water plan said, we'll deal with that later, we've got plans, we'll let you know later. You would then have said, as you said at the show cause hearing, that's not enough. No, they didn't. But my argument is that they cannot submit any water plan. You've got to determine whether or not that water plan is in fact viable. If it's not a viable plan, then they have not remedied the deficiency in their application.
Exactly.
I strongly suggest that this board deal with that issue first, before we then move on and go full steam ahead into the hearings, costing everybody time, money, and expense.